The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this afternoon's IT governance webinar on how an ISO 27001 compliance information security management system can help firms achieve GDPR compliance. I'm Alan Calder. I'm going to be your host this afternoon. I'm the founder and chief executive of IT Governance, which is a company I set up about 15 years ago in order to create a one-stop shop for organizations of all sectors and sizes to be able to access in a single relationship with an account manager a comprehensive range of data protection and cybersecurity related services. The origins of the business are in a book I wrote about data protection and information security, which has been the Open University's postgraduate textbook for information security for the last 5 editions, and I believe is about to go forward to become a new edition at the back end of this year. So IT governance as a business grew out of a publishing activity, and publishing is still a key part of what we do. It's alongside our software business, our e-learning, consultancy, training, and distribution businesses, part of the variety of different ways in which we help organizations tackle the broad governance, risk management, and compliance challenges that become increasingly important to organizations today. Cyber resilience is very much at the heart of that range of activities, and data protection, particularly now driven by GDPR with the privacy regulation, and for critical national infrastructure, the Network Information Security Directive, all bearing down on us. We are able to deliver a integrated set of services that will pick up business continuity, payment card industry, compliance, penetration testing, breach reporting, incident response, and all of the components that for any organization adds up to a compliant and resilient capability to withstand today's cyber threats. While I'm assuming that most of you being involved in law firms already have a working knowledge and understanding of the General Data Protection Regulation, I am, for the purposes of identifying the key issues in terms of looking at how ISO 27001 might help address GDPR, going to just run through some of the headline areas that GDPR creates. I think the challenge for all firms is the same as the challenge for organizations at large, which is that GDPR is a very comprehensive body of legislation tackling a fast-moving and complex area of business activity. And in a number of specific areas, the legal requirements are not yet perfectly defined. Most of the legal requirements are going to be subject to interpretation and further court findings and challenge. But in the meantime, organizations have got the issue of determining how they will go about complying with this law. So I'm going to have a look very briefly at GDPR's impact on the legal sector, touch on at a summary level the legal requirements and the obligations on firms, and how an information security management system can both help compliance and provide a safe harbor in terms of dealing with the possibility of penalties, financial penalties, and data subject action. The role of robust staff awareness training and supporting cyber resilience, and some practical advice on how the firm's overall information security posture can improve in line with the requirements of GDPR. I'm probably going to talk for about 40 or 45 minutes as I work my way through that agenda. It wouldn't surprise me if you find that you have 1 or 2 questions that you might like to ask, and even might like me to answer. I'd encourage you to use the questions functionality sitting in the GoToWebinar control panel. Is a box marked questions. If you click on that and open it up. You can type questions into it. When we come to the end of the prepared part of this afternoon, then I will be able to turn to the questions. And what I'll do is I'll read out the questions starting with the earliest. I'll share my response with you, and then I'll try and get through as many questions as is possible to do in the time that's available to us. And I'm expecting to spend no more than an hour in total on this, so the webinar should finish as advertised at 4 p.m. British Summer Time. So, an overview of the GDPR and its impact on the legal sector. Just to summarize the data protection model under the GDPR, the starting point for data protection is that data subjects, you, me, the firm's clients are data subjects, and we have rights. And data subjects are natural living persons, as you know. Deceased persons don't have rights. Legal entities don't have rights under GDPR. It's only living persons, natural persons, who have rights. And data subjects, if they give their data to a data controller, and there's a multiple number of ways they might do that and reasons why they might do it. The controller, typically an organization, but could be a partnership, could under some circumstances be an individual, has obligations to deal with that data in a particular way. So in return for the respecting the rights of data subjects are the duties of the data controller. Data controller, who is simply defined as the entity that determines the means and purposes of processing, can outsource some of the processing to a third party. And data processors are legally defined for the first time, and they are a third party that processes data on behalf of a data controller. So the assumption of GDPR is that controllers will mostly do their own processing. The conversations you might have had under the Data Protection Act, as was, of some organizations are processors and others are controllers, and sometimes an organization is both. That falls away now. A controller will typically process data itself, or it will process data on behalf of a controller, or it will outsource the processing to a processor. Processors are third parties. And the obligations the controller has in respect of third parties relate both to security and to transparency. Data controllers can also move data out of the country within which it's collected to third countries. There's a set of rules about how that should be done. And the particularly challenging aspect of that is, of course, that increasingly we use cloud service providers, and the definition of data processing includes storage of data or access to data. And many cloud service providers store data outside the European Union, which means the technique gets processed outside the European Union. Therefore, firms have got to think about how they go about ensuring that that processing is taking place within the context of GDPR. GDPR also recognizes that third parties are involved both in the collection of data and might be entities to whom a controller has to expose data. So it's entirely possible, for instance, in marketing terms, that organizations might still buy a mailing list. That's perfectly legal thing to do. It's not unusual in the legal sector that information about clients is referred to you by third parties. All of that continues to be legal as long as you're dealing with the data in line with the requirements of GDPR. Data controllers can disclose personal data to third parties, again, as long as it's in line with the requirements of GDPR. It's the Information Commissioner's Office that is the supervisory authority responsible for assessing and enforcing compliance with the GDPR. The European Data Protection Board is came into existence at the same time as GDPR came into law, to ensure a level playing field across the European Union, to make sure it's not a super regulator, it's a body to ensure that the interpretation of GDPR is consistent, that judgments are consistent, and so that what is intended to be a level playing field is in fact a level playing field across the whole of the 28 member states of the European Union. So that's the model. ISO 27001 has a an important role to play in ensuring that those interactions are carried out in a way which meets the requirement of the sixth principle, which is to protect data, but also which enshrines each of the key roles in the information security structure of the firm and of the ecosystem within which it operates. The starting point, as I said, really is the rights of data subjects, and the controller is required to facilitate the exercise of the rights of data subjects, and those rights start with the right to be informed. So we know that that shows up in the form of privacy notices written in accordance with either Article 13 or Article 14, depending on where the personal data was sourced. The rights of the data subject have access to the information to rectify incorrect information. Under certain circumstances, the right to have data erased, the right to restrict processing of data while a dispute might be carried on around the appropriateness of the processing, the right to object to processing of data in those circumstances where the data processing is not taking place on the basis of consent, the right under, again, restricted circumstances to data portability, and the right to be informed of the existence of automated decision-making, including profiling and the likely outcomes of that profiling. Where consent is the lawful basis of processing, then data subjects have got the right to withdraw consent, and there are several circumstances under which consent is quite clearly invalid. So consent is invalid for processing the data of a firm's staff. The relationship between the firm and its staff is unequal, and so consent can't be freely given. The consent can't be given in terms of processing of personal information by public authority for the same reason. But where consent is given and it's appropriate, a data subject has the right to withdraw consent, and the controller has to stop and ensure through their supply chain processing stops. You therefore need to think carefully about the circumstances under which you're going to rely on consent. You wouldn't want to rely on consent where you're processing data for the purposes of a financial transaction, for instance, because if the data subject withdraws consent, then you're stuck with the challenge of how to deliver the goods they've purchased. They also have the right to lodge a complaint with the supervisory authority, and it's this specific right that's the first of two key areas for firms to think about in terms of staying out of trouble where GDPR is concerned. Yes, of course, GDPR requires a number of legal actions, but fundamentally, if you think about GDPR, it's saying protect personal data, and it's saying that the Information Commissioner has the right to take action where a firm fails to do that. And the two ways in which the Information Commissioner gets to know that you failed to protect data are, first of all, when the data subject reports that there has been a data breach, or brings an action in a court which they're entitled to do, or simply raises a complaint with the Information Commissioner. Those are the circumstances under which the Information Commissioner becomes aware of the fact that it may be that you're not complying with GDPR. And that very fact means that unless you are absolutely certain that you've got no data subjects who might have a gripe or who might have grounds for a complaint, means that you have a potential exposure. And so thinking about how you not just put the right processes in place, but thinking about how you protect the data in that exchange, thinking about rights of access and so on, are all key parts of ensuring that you are actually effectively in compliance with GDPR. I talked briefly earlier about the issue of international transfers. GDPR applies to organizations that are outside the European Union providing services into it, and it also applies to organizations who are not in the, sorry, it applies to organizations outside the European Union providing services into it, irrespective of whether those services are paid or unpaid, and it applies, of course, to organizations based in the European Union, irrespective of where the processing takes place. So if you're an EU business and you happen to have an office in New York and you're processing the data of data subjects in New York, but the New York office is not constituted as a separate standalone arm of the firm, it's part of the UK firm, then the processing of that data in New York falls within the requirements of your GDPR compliance in the UK. So the clarity has to be, first of all, that if you're based in the European Union and processing personal data, irrespective of the place of residence or citizenship of the data subject, you and all of that data is within scope. If you're outside the European Union providing services into it, then those data subjects, not an EU citizen issue, it's those data subjects within the European Union who are accessing the service are within scope to be protected under GDPR. So it's quite a comprehensive set of requirements. And as I say, I keep stressing the words protect. Protect is where ISO 27001 comes in. Your obligation is to protect that data. And the failure to comply with GDPR, which practically speaking can mean the failure simply to protect data, the failure to satisfy individuals the data is appropriately protected, can lead to financial penalties. And again, as I'm sure you know, that the penalties can be for lesser transgressions up to 10 million euros or 2% of global turnover, and for major transgressions, which typically are in and around areas such as breaches of the 6 data processing principles, breaches of the 8 data subjects' rights, or breaches of the transport or processing requirements, those financial penalties can go up to 4% of global turnover. While financial penalties are under GDPR intended to be dissuasive, they also have to be proportionate, and they have to take into account the imposition, they have to take into account the extent to which technical and organizational measures have been implemented and the extent to which the organization has been negligent. So you can think of the business of compliance as being about how do we make sure that if we report to the ICO, we can have any potential fines minimized by demonstrating that we've got in place appropriate technical and organizational controls, and that we've been not at all negligent in terms of meeting our accountability under GDPR. And that's really where you begin thinking about ISO 27001, because the challenge, as you'll know, in demonstrating compliance with the law is how do you do it? You could really only do it if you had a judge come and carry out an order and say, yes, as I understand the law, I think you're compliant with it, but that wouldn't stop somebody else challenging you and bringing a case that said that was wrong. So your issue is, how do I go about demonstrating that I've been not negligent, I've done the most appropriate, I've done my best endeavors to protect data within the requirements of GDPR. And protecting data, given the requirements to demonstrate technical and organizational controls, means going further than simply cyber essentials or penetration testing. It means putting in place a framework that enables you to demonstrate that you've dealt with the requirements in both of those areas, technical and organizational controls. And so it's worth thinking about the 6 data processing principles, because they very practically set out the starting point for thinking about what the firm has to do. So Article 5 says that here are 6 principles. Data must be processed lawfully, fairly, in a transparent manner, collected for specified, explicit, and legitimate purposes, must be adequate, must be accurate, retained only for as long as necessary, and processed in an appropriate manner to maintain security. And while you might think that ISO 27001, which is an information security management system standard, would really only bite on the 6th principle, the reality is that it bites across all of the principles, because it's a management system which looks at how data is processed. And that includes how data is collected, who has access to it at the various points during which it's being processed, how long it's stored for, how the storage is protected, how you cleanse data. They're all elements of an effective information management process. So ISO 27001, and we'll look at it in a bit more detail just now, enables you to, from a structured, internationally recognized standpoint, tackle all of the 6 requirements of the data processing principles. And that's a sensible approach, because the seventh principle, or what's in effect the seventh principle written into the Article 5, is the controller has to be able to demonstrate its compliance with those 6 data processing principles. And we call that the principle of accountability. In effect, it's the seventh principle, the reality that the organization top down and the firm from partners down says, we recognize that we have this obligation and we'll take appropriate steps to comply with GDPR, to comply with the 6 processing principles to protect personal data. So the 6 data processing principles are the first point to be thinking about. How do you demonstrate you're complying with them, bearing in mind the larger fines bite on breaches of those 6. Article 12, supported by recital 59, says the controller has to facilitate the exercise of data subject rights. That means that it's no good just recognizing the data subjects have rights. You have to make the step on from there, which enables them to understand how you will help them exercise their rights. You need to tell them what they are, and you need to have processes in place for exercising them. Now, one of the obvious requirements in helping people exercise their rights, you need to make sure you know who they are. So you're going to need to get more personal data from them. You're going to need to store that securely. You're going to need to deliver the data up securely. You're going to be able to need to access the data wherever it's stored. So you're going to need to have efficient and effective data storage methods. You're going to want to deal with the possibility that you have data stored in multiple archives, both analog and digital, because data subjects have a right to know about all of that data, and they've got a right to have changes made to all of it. So in order to get yourself into a position where you can meet the requirements around facilitation of data subject rights, you also need to have put into place an effective and comprehensive approach to managing information across the whole of the firm. So you've got to think, therefore, about obligations. You've got to think about obligations not just for you, the data controller, but you've also got to think about obligations on the data processors. So let's think about data controllers. You've got, in collecting data, to think about what the lawful basis for collecting that data is. You've also got to make sure that in collecting the data, you're doing so in a secure and adequate manner. You've got to decide what data to collect. So what's the content? You've got to think about, if you're collecting it online, what the content of web forms might look like. You've got to make sure that the collecting of the data in a web form is itself secure. What are we going to use the data for? How do we ensure the data we've collected for one purpose can't be redeployed for some other purpose, because that would be a prima facie breach of GDPR? Whose information are we collecting? If we have to disclose it to someone else, how do we do that? You need very clearly drafted procedures which are linked to rights of access and rights of supervision to ensure that the disclosure of data is properly authorized. You need to have worked out how you're going to apply the relevant exemptions. And there are a number of exemptions that do exist in terms of what data you might provide to somebody. There are obvious exemptions in terms of where information covers 2 data subjects and you need to redact that related to one and provide that which relates to the other. How long do you retain data for? How do you protect data through its retention period? All of those are clear obligations on data controllers. Now, one of the biggest obligation on a data controller that chooses to outsource some or all of its processing is that it's responsible for the processing. It, the controller, is accountable for all of the processing of the data that's carried out by its third-party data processors. So Article 28 sets out the requirements around the processor contracts. Processors have to have a legal contract. That's the starting point, and that contract has to set out very clearly what the processor is to do with the data. Requires them to take appropriate security measures. You have to, as the controller, judge whether those measures are actually secure or not. If you're going to allow a processor to engage another processor, then you're going to have to put in place requirements around the way in which that processor meets your existing requirements, the selection and implementation of appropriate technical and organizational measures, ensuring the processor and sub-processors are in compliance with those returns. And at the end of the contract, you need to ensure the data is returned and that the processor is able to, and that you enable the controller as the processor to meet all its compliance obligations under the regulation. So as a processor, you need to have a framework that enables you to interact effectively with those controllers for whom you are suppliers. As a controller, you need to have a mechanism that enables you to demonstrate that you've understood that you're accountable for the processing of data by the data processors you've selected, and also for managing the security and appropriateness of that processing. You're also required to have records of your processing activities. So Article 30 requires all organizations to have effectively a register which describes what data you've collected, what for, what you're doing with it, should be providing contact details for the organization and its DPO if there is one, the categories of processing, the people with whom the data might be shared, should set out how international transfers are dealt with, and the time limits for retaining the data, as well as a general description of the technical and organizational security measures implemented. So you have it there. Article 30 says your records of processing need to include a description of the technical and organizational security measures implemented. Most firms struggle to be clear about what those are. If you have a look at the number of law firms that have reported data breaches over the course of the last 18 to 24 months, many law firms have inadequate technical and organizational controls in place. GDPR isn't just saying you need to do better, it says you need to document what they are. And ISO 27001 makes a huge contribution to your doing that. So specifically now looking at GDPR, where it's talking about security of information. You remember that the 6 data processing principle says you must process data in a way that's likely to ensure its security. Article 32 goes a bit further. And if you think of the 6th principle as applying specifically to the data which is collected, so every element of data which you're collecting, you need to be able to apply those 6 principles to. You can think of Article 32 as looking at the overall activity of the organization. And specifically, it requires organizations in general and firms specifically to take measures to pseudonymize and encrypt personal data. And pseudonymization is a security technique. Anonymization takes data out of the scope of GDPR. Anonymization effectively renders it impossible to identify the data subject, whereas pseudonymization breaks data up into a number of pieces such that on their own, they're not enough to identify a person, but when put together with the other elements, a person's identity can be ascertained. Encryption should become a default security mechanism for all organizations. Security in the eyes of GDPR and of the Information Commissioner effectively means that if there is a breach, there is no risk to the rights and freedoms of data subjects. And the big benefit of that is that if there is no risk, then as a data controller, you don't need to report the breach to the ICO. So Article 32 says take measures to pseudonymize and encrypt personal data. Take measures to ensure the ongoing confidentiality, integrity, and availability of the way in which you process data, as well as of the data. Take measures to be able to restore availability and access to data in a timely manner in the event of a technical incident, recognizing that incidents do take place, and or implement a process for regularly testing, assessing, and evaluating the effectiveness of what you've done to protect the data. Article 32 is in effect asking you to put in place a framework that enables you to demonstrate that you've got appropriate technical and organizational controls in place. How do you determine what's appropriate? Appropriate could differ from organization to organization. It could differ depending on the type of data and the value and importance of the data that you've got. Organizations are perfectly at liberty under GDPR to make the decisions themselves as to what constitutes appropriate controls. But you need to have some documentation, go back to the accountability principle, which indicates how you arrived at that decision. How did you determine that encryption wasn't necessary for data in this environment, but was necessary for data in that environment. Accountability, if there's an investigation, requires you to be able to point at the trail that led you to make a decision that led you to have done whatever it is that you've done. The fact that what you've done might be wrong is going to be hugely reduced in terms of implications, in terms of financial penalties, because the process you've gone through is a clear and transparent one, where you may have made an error, but there is no evidence of negligence. So an information security management system, and ISO 27001 is simply an international standard. Like ISO 9001, ISO 27001 is an international standard. It's been around in one form or another since late 1997, so it's been through a number of iterations, a number of improvements, that sets out what's globally recognized as best practice in managing information security in organizations of all sizes. It's specifically written for firms from 2 or 3 people up to hundreds of thousands of people. It's capable of operating in single-site organizations, just as it is capable of operating in multi-site, multi-jurisdiction organizations. So it's a best practice information security management system. It's technology agnostic, it's sector agnostic. It simply sets out best practices in how to manage information security and makes reference to a set of relevant information security controls. Not surprisingly, because ISO 27001 now has, or has had for a long time, an internationally recognized and accredited certification scheme attached to it, which means that if you claim to have complied with the requirements of ISO 27001, you can have an independent auditor audit your data protection activities against the requirements of ISO 27001 and issue you an independent certificate of compliance against ISO 27001. Now, ISO 27001 very specifically is focused on managing the confidentiality, integrity, and availability of all information, not just personal data, but is also designed to align with internal and external drivers and written in such a way that it can specifically reflect precise requirements of legislation such as the GDPR. So ISO 27001 is a way that an organization can determine what it should do in order to implement an effective information security management system. You don't have to work it out all from scratch. You can buy a copy of the standard and go, okay, I will do this. And because it enables you to put in place to meet a set of requirements, you can also have an audit carried out against how you've complied with those requirements. And an audit can be carried out by an accredited certification body, typically somebody like BSI or LRQA or SGS or one of those. There are many certification bodies in the UK that do ISO 27001 audits, and they will typically do an initial audit at the beginning of a certificate period, and then the certificate expires after 3 years, so you'll have a repeat audit, and there'll be interim audits usually every 6 months during the interim, so that everybody has the assurance that the system is in place and is being externally audited. So it's not just the internal information security team who says that your information security is adequate, but you have an external body that's competent to do this, also telling you that it's adequate. There are many other benefits that come from ISO 27001 other than just, gosh, we have assurance that we're secure. Of course, it enables you to demonstrate to regulators and to customers that you're secure. It enables you to demonstrate to clients and partners that you've got an appropriate management system. It enables you to say to partners and suppliers when they push back against what you require, you're able to say, well, this is part of best practice, not just us being difficult. That's why we need you to go along with it. And that can help you win new customers, help you retain existing customers, can help you cut down on the number of audits being carried out by larger suppliers, because you can say to them, hey, I've got my biannual audit, here's the outcome, you don't need to come and audit me yourself. It also means that the organization not only does it have the assurance of being able to manage its own information security, it's got the assurance that it's managing it cost effectively, it's protecting the confidentiality, integrity, and availability of all its data from a legal firm's point of view. That's not just client data, but the confidential nature of many law cases means that protecting it through until the point that it might have to be shared in court is important. It reduces costs. It can facilitate compliance with a number of other laws and regulations. So ISO 27001, a technology and sector agnostic framework, is a really sensible and practical starting point for an organization looking for some way of demonstrating that it's meeting its GDPR requirements. Now, ISO 27001 is a people and process framework. Typically, when you're looking at data protection and cybersecurity, you're looking at three domains. You're looking at technology, people, and at process. And to an extent, of course, all controls, all appropriate technical and organizational controls are a mix of each of those. So you can't be sure that a firewall is correctly configured without having a configuration process document, having someone authorized to configure it, having a preferred set of configurations, and have the appropriate level of training. So you need people and you need process to have your firewall working correctly. But broadly speaking, being able to demonstrate that you've got appropriate technical and organizational controls is going to come down to demonstrating that you've got controls which cover people, process, and technology. And those are the three pillars of ISO 27001. In the same way that ISO 27001 focuses on the preservation of the confidentiality, integrity, and availability of data, so it's built on recognizing that you need to act in each of the domains: people, process, and technology. So it's a GDPR requirement that you demonstrate compliance with the sixth data processing principle. Quick read across, we have ISO 27001, we're certificated to comply with it. Very straightforward evidence of the fact that you're in compliance. Article 32 says that you must protect data, sets out a number of ways in which you must be able to demonstrate that you've taken appropriate steps. Somebody asks you, how do you comply with Article 32? You say, here's a copy of my ISO 27001 management system certificate. You have a customer or a client say to you, how do I know that you're processing data in compliance with the GDPR? You go, here is my certificate of compliance, and here is my data protection policy, which quite clearly says that in order to achieve ISO 27001, I'm also complying with GDPR, and that my policy is required to, my data protection policy is required to be reflected in ISO 27000, and we have been audited on that basis. So ISO 27001 is a mechanism for ensuring that you can have adequate, independent review and audit of your compliance activity. It also ensures that all of your confidential and sensitive information is protected, because it's a management system that deals with all types of information, digital and analog. It deals with voice information, pictures, and helps you make sure that, having carried out a risk assessment, you've got the appropriate level of security in place. It's supported by ISO 27002, which is a standard that provides guidance on implementing a set of 114 different very specific technical and process-oriented controls. And that means it's very easy for you to go from management system to controls in one complete suite, and it's systematic. One of the challenges that many firms have from year to year is that the information security team might change, and that can lead to changes in how you deal with information security, whereas an ISO 27001 ISMS is an international standard. The fact that you comply with it, that you carry out a risk assessment in line with its requirements, means that you've got a management system which gives you repeatability, durability, and robustness. You've got a clear, consistent starting point month after month and year after year. So not only do you get that level of robustness, but the other thing you get with ISO 27001, because it sees people and the compliance activity of people as important, you will see the drive for implementing a robust staff awareness culture inside the organization. I think it's worthwhile talking briefly around the role of staff awareness training from a GDPR and cyber compliance perspective. Inside a law firm, almost everybody is dealing with personal data to one extent or another. Somebody operating on the client interface is collecting client names and contact details in order to get back to them. Somebody working with a barrister's chambers or vice versa is going to be sharing data, working with specialists. All of those are going to be sharing data, and you need anybody sharing with data to be aware of what the firm's obligations are and how the data needs to be protected. GDPR compliance requires that. And ISO 27001 creates a framework within which you can do that effectively. It creates a framework within which the identification of user roles and the allocation of user access rights to both digital and analog information can be addressed systematically. It can help identify areas of weakness where, as the management, you've attempted to make the organization more secure. It can ensure that all members of the firm are properly educated on their responsibilities and the consequences of their individual actions. Staff awareness training helps embed processes, and you'll remember that GDPR requires data protection processes to be embedded, and that's exactly what ISO 27001 does. The cycle of audit and remediation means that processes get embedded reasonably quickly and changes to them are properly and responsibly managed. And you really do want all members of the firm, therefore, aware of the firm's compliance requirements, and staff awareness training is an effective way of doing that. So putting everybody through an appropriate staff awareness program can have multiple benefits for the firm. Can identify common drivers or resistance or gaps in understanding in terms of driving firm-wide buy-in to and acceptance of the requirements of GDPR. A mix in an e-learning training program of different methods of serving up learning can mean that you address the different learning needs requirements of different individuals very cost effectively. The fact that you can evidence somebody having done the training means you've got hard evidence that they knew what they were doing, and that when they are in breach of GDPR, they can't therefore claim ignorance. One of the most important parts of online staff awareness training is the reality of the audit trail that it gives you. Of course, as you have more and more staff inside the firm able to recognize the requirements of GDPR, so you get more and more people signed up to the idea of improving your processes and improving how you go about meeting your compliance obligations. And that over time can drive significant process improvements, savings in processing time, reduction in process periods, and of course reductions in data stored. This involvement of everybody is a big driver for continual improvement, ensuring that GDPR remains at the forefront of what everybody does. So where do we start? Where do we start with ISO 27001? Well, you could think of starting with Article 30 or Article 32. Article 32 is the information security requirements, but Article 30 is the requirement that the firm creates a record of its personal data processing activities. This is drawn from a data flow audits and gap analysis, and that the Article 30 documentation recognizes, identifies the appropriate technical and organizational controls you have in place to protect all of the data that you've identified through your data flow audit. Of course, the data flow audit should enable you to determine exactly where you need to put links to your privacy notices, enable you to get clear as to where you're relying on consents and where you shouldn't be, should drive you to update all of your current contractual arrangement with employees, customers, suppliers, and other bodies, should ensure that you've got appropriate administrative, technical, and organizational measures in place to protect data, supported by appropriate policies and procedures so that you have a growing culture of managing privacy rights of data subjects. And Article 30, if you remember, is looking for you to document how you manage privacy, taking account of the risks to the rights and freedoms of data subjects. So you have to choose and select controls taking account of the risks to data subjects. The only way you can do that is by doing a risk assessment. And a risk assessment requires a risk management framework. It's not something which you should do on the back of a cigarette packet, assuming that you still have access to cigarette packets, but it's a standard formalized approach. It starts by creating a risk methodology. It continues then to create a risk scale where you recognize that a risk is the combination of the likelihood of something happening and the impact on the firm if it does happen. So the likelihood of a tornado in the fens of East Cambridgeshire is low, but the impact is high, and that might lead you to decide that the risk itself is low. On the other hand, the risk of torrential rain and the likelihood of flooding for a building which is built on the floodplain in the Midlands or in the Fens is high, and so you would put in place different controls, different measures to protect data in the latter than you would in the former. So you need a risk scale, you need to determine what the risk appetite is, and you need to take account of what contracts, regulations, and legislation says you must do. So GDPR, for instance, says you have to look at basically circumstances where there is no risk to data subjects, where there is risk, and where there is high risk. And so when looking at privacy risk, you need to be assessing it on those three levels, whereas you might be looking at risk to the organization perhaps on 5 levels. Whatever you do, you need a risk assessment methodology, a formal risk assessment methodology, out of which you can determine how you're going to select and apply controls. And so stepping back a minute, recognizing that ISO 27001 probably gives you a route to early demonstration of appropriate steps to comply with the requirements of GDPR. How do you implement an ISMS? There's a very straightforward 9-step program. We're probably the organization in the world that's done most to help clients establish ISO 27001 certifications, to the point where we provide a certification guarantee that whichever third-party certification body you choose, you will be certified. We will do the job adequately to bring that about. And the starting point, of course, is a project mandate. Why are we doing this? And the commitment of resources that are necessary, the partner level commitments to the project, the identification of information security goals, creating then a project team and getting the project off the ground, a RACI matrix which identifies roles and responsibilities, and then getting your documentation moving. The documentation the ISMS requires is going to be a crossover with some of the documentation that GDPR requires, and so your Article 30 requirements is the logical place to link into ISO 27001 Step 3. Step 4 is to build out the management framework. What is the scope of the management system? Which of your suppliers are in scope? Which clients, which partners, which other bodies that you're dealing with? How do you communicate with them? How are you going to communicate internally? What kinds of competences do we need inside the firm in order to implement ISO 27001? Our IT team or our outsourced IT suppliers almost certainly won't have the necessary competence. They should be able to either bring it in or you need to bring it in, but it's going to be a specific understanding of how to manage information security in the context of GDPR that you need. You'll then identify what we call baseline security criteria. Those are the controls that you have to have in place to meet your GDPR and your practicing certificates requirements. There will be specific controls around protection of personal data, access to personal data, integrity of data, and so on. And having done that, you will look at the additional controls that you need to put in place to deal with any other risks that you might have identified. And it's that risk assessment framework and the risk management options that enables you then to produce what we call a statement of applicability. It's the list of controls that are in Annex A to the standard to ISO 27001, identifying basically which of the controls you have selected and explaining why and explaining which ones you haven't. And the reason you do that is to provide a point of reference to any third party and obviously to the information commissioner to understand from a top level what you've done to protect data. You then implement it. You do a needs analysis, you establish a staff awareness program. You make sure that the management system and all of its selected controls are driven across the whole of the scope of compliance. And then you start monitoring. You remember the requirement under GDPR that you measure, monitor ongoing compliance with technical and organizational reviews. That's not just about penetration testing. It's also about continuing to carry out internal audits around your data protection and information security practices. Putting that information in front of the relevant senior partners to ensure that from the firm's perspective you are thoroughly in compliance with firm's objectives, and maintaining your certification. In order to do that, you need to have all of the records that I've touched on. Management needs to be involved. The senior lawyers and functional staff who are involved in protecting data need to be quite clearly involved in driving security across the firm. So 9 relatively straightforward steps. Anybody who's had a proper practitioner training and had some experience would be able to help you do that. And of course, it's a methodology, a 9-step approach, which we've perfected over hundreds and hundreds and hundreds of ISO 27001 certifications. And IT governance is, as we set out, to be able to help organizations tackle ISO 27001 compliance in any one of a number of different ways. We have a set of GDPR training courses, so foundation and practitioner courses delivered in classroom and delivered live online, delivered through distance learning. We have a DPIA workshop, and obviously DPIAs are looking at impact on data of security risks, so DPIAs feed very directly into ISO 27001. We have classroom, online, and distance learning versions of lead implementer and lead audit courses for ISO 27001, as well as the ISO 22301, which is the business continuity standard training courses. So if training is what you need, we've got an offering around training. We've got an offering around self-help materials. If you want to tackle this thing yourself and you simply need access to a copy of ISO 27001, you can buy the standard off of our website. You want copies of documentation toolkits or gap assessment tools. Our documentation toolkits are designed so that our GDPR documentation toolkit will interface with the ISO 27001 toolkit, will interface with the business continuity control kit, so you can build a compliance framework over time, knowing the documentation will continue to integrate effectively. If what you need is consultancy support, we can do that too. And many of our legal sector clients engage us because their fee earners are hard at work selling data protection and information security services to their clients to the point where they don't have time to do the things which they're selling their clients. So we, of course, are in a position to do that. We somehow find the time also to ensure that we are GDPR compliant. We have an ISO 27001 certificate and so on. So you can get gap analysis, data flow audit you can buy if you have to, if it's mandated for you, or much more likely through choice, DPO as a service. We can help build cyber resilience inside the organization, and we can help with incident response and data breach reporting. Or we can put together a mix of those services to suit any particular firm's particular culture and approach to meeting its information security and GDPR obligations. There are a number of free resources which make available. There are GDPR products. We have GDPR webinars. We have a whole range of tools, both as I said for GDPR and for ISO 27001. We can help with Cyber Essentials, which is the lower level government framework for demonstrating that you've dealt with something like 80% of common or garden internet threats. We can help with that whole range of things. And so next steps really is thinking about what do you do? Perhaps the next step for you might be registering for the next webinar, which we have running on the 5th of July. It's the responsibilities of controllers and processes under the GDPR and how staff awareness training can support compliance. You can register for that now. And that brings me, ladies and gentlemen, to the end of what I had planned to say. So in the remaining 7 or 8 minutes, we can deal with any questions you've got. And just a reminder, if you do have questions, the thing to do is to put the question, type the question into the question and answer box in your GoToWebinar panel. And what I'll do is I'll try and pick up the question. I'll share the question with you, and then I'll give you my answer, and I'll get through whatever questions we've got. So we have IT support companies who have access to database with clients. They sometimes require access to the database and personal data of our clients for maintenance and support. Do you need a contract with a support company in terms of a controller and processor relationship? Yes, you do. The fact that they're able to access your database, they're almost certainly going to be responsible for hosting the database. I'm suspecting they're going to be responsible for hosting the database. They're certainly providing maintenance support. They can access the data. Accessing the data is under GDPR quite clearly defined as processing data, just as is storing data. So you need a contract with them, or they need a contract with you, which tells them what they can do, sets out very clearly how they do it, and what your requirements on them are in terms of how that data is processed. We mail previous clients with current services products which may be of interest to them. These customers can go back 10+ years since they last used our service. They can call up and request we stop mailing them any time. If the previous customer requested how we obtained their details, we can give a good account of date the service was purchased from us. However, we will not be able to provide them with details of the product or service they originally purchased, which added them to the mailing list. Is this a breach of GDPR? And the answer is no, not necessarily. The situation is reasonably complex, but our view, and I think most sensible people, certainly the view of our in-house lawyers, is that where you have had a contact with customers and you have been in email contact with them and you have been sending them information on a specific subject or a specific range of subjects, and they've been able at any time to opt out of that mailing, even though you no longer remember where you got the data from, because it wasn't a requirement back then that you should be able to do so. It's a requirement now, not that you remember where you got the data from, but that you tell the data subject where you got the data from and what you're doing with it. And frankly, you could say to the data subject, I already have your data, and this is what we're doing with it. So the obligation is a data privacy notice as set out or in compliance with the requirements of Article 13 of GDPR, sent to all of the data subjects. And in that privacy notice, you're going to be saying, we have always been mailing you. We intend to continue mailing you. We have a legitimate interest in doing that. Legitimate interest is defined in one of the recitals as a lawful basis for processing data. And we provide you with a basis, a method for objecting to that. And this is how you object. You can easily opt out. We've facilitated your objection. Click this link and we will we will stop processing, unless of course there's an overriding obligation on us to continue, such as a statutory or contractual reason to continue processing the data. The one thing I would suggest you think hard about is the retention period that you apply to the data. So you've got data on there which goes back some 10 years. It's entirely possible that some of those people haven't dealt with you in 10 years. And so in thinking through your retention policy, because GDPR requires you, if you remember, to not only determine the means and purposes of processing, but to keep the data for no longer than is necessary for the purposes of processing. If the purpose of processing is to introduce products and services to customers such that they can be informed or buy them, you probably want to have some mechanism for establishing whether they're being informed or not. So you might want to look at bounce backs, or you might want to look at evidence that people have opened emails. You might want to look for evidence that people have purchased additional services. And you might want to have in your retention policy that if there is no response of different types within different periods, you will cease processing the data on the basis that it is no longer you're no longer able to process it for the original reason that you collected it. One area where you probably want to talk to your own fee earners to get a very specific interpretation of how you meet that retention requirement. Where's the best place for a small firm to start with an ISO 27001 project? And the best place is much the same as it is for a large organization. It's to identify what your compliance obligations are and to get senior senior lawyers and senior functionary staff on board with the idea of using ISO 27001 as a mechanism to demonstrate that the firm has actually met its GDPR compliance requirements. And then either on your own or with a company such as us, look at how you can put together an appropriate project. We, for instance, offer to firms of under 20 people what we call a fast track ISO 27001 offering, which is a fixed price offering that enables us to get you from 0 to compliance in usually 3 months with minimum workload for you. There is some work that you have to do, and we've even got a micro fast track for firms of 10 people or fewer. So in terms of help, that's one sensible place to think about looking for help. We're just beginning to run out of time. I have time for another question, so let me just try and deal with one more question before we finish. Are contracts required for all vendors who assist with processing data? For smaller vendors without formal contracts, is there an alternative means for which to put in place appropriate terms, coverage that would provide a level of compliance? Well, GDPR says that a processor may only process data within the terms of a contract. So I guess, no, there are no ways in which you can outsource the processing of data without putting a contract in place. Now, you might choose to do that by means of publishing your terms and conditions of processing on a website and having your processor simply agree that they're going to comply with those terms. You might make it quick and easy like that, and that's what many large organizations will in fact be doing because they don't want to be bothered by having to argue over customized terms for every single controller or processor client, depending on which way they look. But that's a pretty practical way to minimize your overall costs of compliance. But yes, you need to have a contract in place to deal with the processing of data. The only place where you don't need a contract per se, but you nevertheless need to address and you preferably need to document it, is where you have joint controllers. You need to agree between you who is exercising each of the functions of the controller in respect of that data, and you need to have agreed between you how to enforce that relationship. So while it's not specifically a contract as the controller processor requirement is, it's nevertheless something you should be thinking about. And a good question, let me take this even though we're out of time. If an EU citizen travels to the US and uses Uber in the US, does that come under the scope of GDPR? And the answer is no, it doesn't. If the Uber app that you're using, and this is potentially difficult because of course the same Uber app applies and works anywhere in the world, but insofar as the Uber app in Denver is collecting data of potential customers and providing it, in theory, only to Uber drivers in Denver, then it's not providing services into the European Union, so wouldn't have to collect data. But in reality, the test would depend very much on the way in which Uber segments its data, the way in which it structures its networks, and the way in which it operates. And if it has one common framework operating across the whole of the world in the EU and outside the EU, where drivers inside the EU can potentially see the data of people outside the EU, it's arguable that it might have to comply with GDPR everywhere. So in large complex organizations like that, GDPR compliance can be a very significant and challenging issue. Ladies and gentlemen, I'm afraid that means we have come up to the end of our time. So I'd like to thank you all for being with us this afternoon. For those of you who asked the final question, yes, the slides will be made available to everybody on the webinar. They'll go out over the course the next few days. If we can help you with your GDPR or ISO 27001 journeys, please do come back to any one of our websites. You know the address www.itgovernance.co.uk. Thank you and good afternoon.